Millions of users have downloaded Temu. But before placing a first order, each user agrees to a legally binding contract. That contract governs how personal data is collected, how disputes are handled, when accounts can be suspended, and how liability is limited. In this episode of Fine Print Review, we analyze Temu's terms of service and break down the 5 clauses that matter most. This analysis is provided for informational purposes only and does not constitute legal advice. Temu's terms of service apply to all users who create an account or make a purchase on the platform. Like most large e-commerce marketplaces, the agreement is structured primarily to define user responsibilities and limit company exposure. The language is comprehensive and in several areas broadly protective of the platform. Let's begin with data collection. Clause 1. Data collection. When browsing products on Temu, more occurs than simple scrolling. The agreement permits collection of personal information, device identifiers, browsing activity, purchase history, and behavioral data. Some of this information may be shared with affiliates and service providers. In practical terms, browsing patterns may influence advertisements and recommendations both within and outside the platform. Cross-border data processing may also occur. Risk level. Broad, but consistent with major marketplaces. Clause 2. Arbitration. If a serious dispute arises, most users will not be going to court. The agreement includes binding arbitration. This means disputes are resolved privately before an arbitrator, rather than through a public lawsuit. The terms also include a waiver of participation in class action lawsuits. Users must pursue claims individually. Arbitration structures like this are standard across large technology platforms. Risk level, standard. Clause 3. Termination rights. Temu reserves the right to suspend or terminate accounts at its discretion. If an account is flagged for suspected violations, access to order history or credits may be restricted. The language grants the platform flexibility in enforcement. This is common among marketplaces, but it places significant control in the hands of the company. Risk level. Broad enforcement discretion. Clause 4. Limitation of liability. One of the most protective sections involves limitation of liability. The terms generally cap the amount of damages that may be recoverable. Certain types of indirect or consequential damages may be excluded. Products are often provided as is, meaning warranties may be limited. Even in disputes involving large transactions, compensation may be restricted. Risk level. Protective, but industry standard. Clause 5. Governing law. The agreement specifies which laws govern disputes and where proceedings must take place. Jurisdiction can influence legal interpretation and available remedies. For cross-border purchases, this section becomes particularly relevant. Risk level, context dependent. Now let's review the fine print scorecard. Data scope, broad. Arbitration structure, standard. Termination rights, broad. Liability protection, protective. Overall risk level, moderate and consistent with large marketplace agreements. Temu's agreement is not structurally unusual compared to other large e-commerce platforms. The key takeaway is not that the terms are extreme. It is that they are comprehensive. Most users click Agree. We read it. This has been Fine Print Review.